Hi, Judge.
Good afternoon. Hi, Cheryl, how are you?
I'm pretty good. Yourself?
Good.
Good.
Hi, Cheryl.
Hey, Mark.
We're just waiting to put your clients in as well.
Okay.
Okay.
My client is only appearing via phone, Judge. She doesn't have a computer to log in.
All right, yeah, but she can listen.
Is her phone number ending in the 613?
The only ones in there should be.
Yes.
Their people.
She's 613? Okay, I didn't know
Yep.
which. Thank you, Mr. Miller. They're all ready and ready to vote.
All right, so we're going to take up case number 16-54415 DO. This is Dale Cook versus Kelly Cook. The court recognizes Cheryl Sterling appearing here on behalf of the plaintiff, and Mark Miller appearing here on behalf of the defendant. Essentially, we've got crossing motions to enforce certain provisions of the judgment of divorce. I would start out by asking the parties if, after filing your pleadings, have you had a chance to discuss the counter motions, and have you reached an agreement as to what should happen here?
We have not,
No,
Judge.
Your Honor, we haven't done that yet.
You haven't talked, or you haven't reached an agreement?
We haven't talked.
Well,
You
as a
haven't
result,
talked?
both, yeah. I mean, I think it's kind of hard, Judge, based on the relief that they're requesting and based on what my client can do. I mean, I don't see how we can resolve that.
All right, well, I've got two other attorneys in a breakout room trying to work through an issue. I gave them until 3:30 to try and do that, so they're going to be coming out of there here real shortly. So my thought was that I would put both of your clients, if they're on the line, back into the waiting room, that we would create a breakout room for the two of you to talk and see if you can't agree, at least narrow what the issues are.
Sure.
Then I'll jump in, I'll bring the other people back and finish off their matter. Then I'll check in to see how you guys are doing. That'll give you a chance to talk and see if there's any common ground, or at least clarify some of the issues. Does that sound like be okay? I'll probably be back to you in about 15 minutes.
Just as long as you remember where you're putting us in all these rooms, Judge.
Well, we can do that. We can find you.
All right.
So,
Okay.
so I'm going to have Choli move you to a breakout room, and we're going to move your clients to a waiting room, and then we're going to put you in a breakout room. I'm not sure if you can chat with your client from a breakout room to the waiting room. I don't know if you can do that.
Okay.
But you can probably have them on the phone, or at least you guys can talk, and I'll touch base with you in about 15 minutes, okay?
Sounds good.
All right. So we're gonna try and send you away to a breakout room. So,
I'm gonna put him in the waiting room first, and then I'll go to the breakout room. See, now it's showing 5 on there. How do I get back?
so you want to go and you can add a room.
Yeah, and it's not give me that option now. I wonder if I have to see if they're not joined. Oh, because they're back in the waiting room now. So I can assign to, I guess I'll put them in one.
No, they're one. So go
Oh,
X
they're
out of
not.
there. X out of there. And then can you go click on breakout room down there?
Yeah, and that's what I was, and it's still showing them. Maybe if I drop down. I wonder because they're not in there now. They're back in the
Oh,
waiting room.
they're back in the waiting room,
Right.
okay. All right, so then send Mark and Cheryl
Into that
to
room.
breakout room 1.
Yeah, that's what I was trying to do. I thought I could do like a 2, but because that should be good to know. I can add Emily and Robert back in charge.
Yes. Okay, we're going to go back on the record with the Drecke versus USAA case. I gave the attorneys a moment to go to a breakout room, and were they able to reach an agreement, or does the court need to issue a ruling in this case?
Unfortunately, Your Honor, we were not able to reach an agreement.
Okay. All right, so the court is going to, my opinion on the issue is as follows. I think the history, procedural history leading up to it is important. So plaintiff filed a summons complaint seeking a PIP, no-fault benefits from USAA on November 14, 2018. The complaint predated the amended court rules regarding initial disclosures. The complaint alleged that defendant owed plaintiff for work loss benefits, replacement services, attendant care, and medical expenses. On December 3rd, 2019, I'm sorry, so it was November 14th, 2019 was the complaint was filed. On December 3rd, 2019, USAA served plaintiff with USAA's first set of interrogatories and request to produce documents. There was also a request to admit that was sent, that the requests to admit were such that no medical mileage was incurred, which was submitted and was outstanding, that there was no work loss, which was submitted and was outstanding, there was no replacement services, which was submitted and was outstanding, that there was no request for attendant care that was admitted or submitted and outstanding, and also the request to admit that the plaintiff had not seen any medical providers since June of 2019. In conjunction with the request to admit, there was a follow-up that said basically if the request to admit was denied, then there was interrogatories that said basically tell me what documents you have to support the claim for PIP benefits. A plaintiff failed to respond within 28 days to the interrogatories that went along with the request to admit, and on January 14th, USAA submitted a motion to compel. Prior to submitting the motion to compel, on January 2nd, USAA contacted plaintiff advising that because plaintiff issued a blanket denial to the request to admit, documentation was required to support reasons or give the backbone for that denial. The letter further pointed out that USAA had not received any claims for work loss, replacement, attendant care, medical mileage, so how could basically anything be outstanding if nothing was in fact submitted? USAA further alleged that they believed all the medical bills had been paid. USAA asked for what PIP benefits were at issue. Plaintiff did file answers to interrogatories on February 10th. Plaintiff submitted medical release authorizations via email and other documents on February 28th. Plaintiff also submitted a medical mileage form for the first time, asking that counsel for USAA submit it to USAA for consideration. The February 28th email from a plaintiff to USAA further stated that plaintiff was completing a household services form and said that it would be submitted in the future. There was nothing indicated in that email that anything had already been submitted, was outstanding, and unpaid. Then interrogatory number 18, and that's of the regular set of interrogatories, asked if plaintiff had any wage loss after the accident, and plaintiff responded they took 2 vacation days for a total of $336. Interrogatory number 37 asked for treatment for injuries, and the defendant responded by submitting medical records, statement of benefits, and directed USAA to look at their own file. In other words, saying, go figure it out, which is not what the interrogatory asked for. Interrogatories 53, 54, 55, 56, and 57 all ask specifically about the PIP benefits. Plaintiff objected to each question as being overly broad, unduly burdensome, seeks information not discoverable, and would not even lead to discoverable information, but in the spirit of cooperation, answered by saying, look at these medical records, look at these statement of benefits, and also go look at your own file. On February 10th, plaintiff answered the request for production number 9, which asked for all documents that plaintiff intended to use to support plaintiff's claims. Plaintiff responded, see attached, and USAA's PIP file. Also attached was explanation of benefits from Spectrum Health, Mercy Health, and Orthopedic Associates and Radiology of Michigan. Those explanation of benefits showed that payment had been received or had been paid by USAA. Those providers had been paid, and included a statement, most of them, not all of them, included the statement that basically, well, those explanation of benefits did not show any past due amounts. It does not show any rejected claims. And in all of the hundreds of pages that plaintiff has submitted, I am yet to see any sort of medical billing to the plaintiff saying that there is any outstanding medical bills. The language on the explanation of benefits further stated that the provider accepts payment in full and agrees not to seek any additional charges from the patient. On February 18th, USAA responded that the motion to compel was still on the docket and included a copy of the supplemental brief in support of the motion to compel. The supplemental brief explained that USAA was seeking 3 things. What claims had been submitted? Number 2, what claims were unpaid? And what payments or bills are outstanding? The documents submitted by plaintiff only addressed the medical costs, which the explanation of benefits said were paid in full. The motion to compel was held on March 20th, and I ordered that plaintiff had 10 days to submit documentation for PIP benefits that plaintiff claimed were outstanding and unpaid. I also ordered attorney's fees in an amount to be determined. Counsel for the plaintiff did not attend the remote hearing, but had indicated that he could rely on the brief that was submitted. Then plaintiff filed a frivolous objection to USAA's proposed order granting attorney's fees, essentially seeking to relitigate whether the order to compel should have been entered in the first place, or whether it should have been taken off the docket just because he was asking counsel for USAA to do so. From the date an order compelling discovery was entered to the present, and certainly not within 10 days, plaintiff has not, to this date, submitted any documentation supporting the plaintiff's claim that USAA had failed to pay any claim for PIP benefits that had been submitted to USAA. Plaintiff's objection of March 11th to the order imposing attorney's fees basically ran through that they filed responses on February 10th that included that, hey, look, we just submitted some claims for the first time, that March 2nd submitted new claims for household services, points out that plaintiff requested the motion to be withdrawn. And certainly he has the right to request that, but he has no right to insist on that. And the plaintiff did not attend the hearing to compel and asked the court to rely essentially on its brief in opposition. On March 2nd, plaintiff indicated that, I think this was emails, that plaintiff indicated that he will be present at the motion to compel and will be asking for costs and attorney's fees to be awarded against USAA in his behalf because it was his opinion that they had complied with the court's order, and also that they had satisfied the interrogatory's answers within a timely manner, and basically that the motion was not necessary. A hearing on plaintiff's objection to the order granting attorney's fees on behalf of USA motion was held, and the plaintiff's motion or objection was denied. At that hearing, the plaintiff's focus on whether it should have granted a motion to compel, and if not, should not have granted the attorney's fees, not whether USA's order accurately reflected the ruling of this court. Plaintiff notably never filed a motion for reconsideration of the motion to compel, nor a motion to reconsider the court's opinion that attorney's fees were warranted, with reserving the right to have a hearing as to the amount. USAA then filed a motion to dismiss for plaintiff's failure to comply with the order compelling discovery. I granted that motion. Plaintiff's focus again was on whether the order to compel should have been entered, and essentially attempted to explain that even though plaintiff had no documentation to support any of the PIP claims that were the subject to filing the complaint in the first place, that filing the complaint was reasonable and necessary to preserve any potential claims they would have in the future. Also notable is that even at that hearing, there was no documentation that the plaintiff was able to submit to say that there, in fact, were any PIP benefits that were submitted and outstanding at the time that he filed the complaint. There was no PIP benefits that were submitted and outstanding at the time that he answered the interrogatories. There was no PIP benefits that were outstanding and unpaid at the time that he denied the request to admit. So the bottom line is that plaintiff, throughout this case, through all these motions, has never come forth with any documentation that says that USAA did not meet its obligations under the no-fault statute for any PIP benefit that was submitted. And that's putting aside whether they were submitted and outstanding as alleged in his complaint and as alleged in all the answers to interrogatories or requests to admit. That's just going forward, that there aren't any. And that, for that reason, among others, the court did grant the motion to dismiss the claim against USAA. Again, there's been no showing that plaintiff has been billed for any deficiency in medical bills, and there's been no documentation that any PIP claim that was submitted has been denied. So that is what led us to today's hearing. And at this point, USAA specifically seeks costs and attorney's fees in the amount of $3,747.94 for the motion to compel, an additional $346.50 to review plaintiff's objection to the order granting attorney's fees and to handle that hearing. MCR 2.313A2 allows a party to file a motion if a party fails to answer an interrogatory. Here, the interrogatories in conjunction with the request to admit was filed on December 3rd. Plaintiff did not file answers within 28 days. The due date was January 2nd, 2020. On the due date, USAA followed up requesting answers, specifically stating that we have not received any claims that haven't been paid, and we haven't received anything for work loss or any of the PIP benefits. No answers were received, or any documentation was received by January 14th. So basically, USAA gave the plaintiff 12 days to submit something before filing the motion. The motion was filed. The motion was justified. Plaintiff filed answers, as I indicated before, on February 10th, after the motion had already been filed. But as I indicated before, those answers were deficient. They did not address the issues that USAA was looking for. On February 28th, plaintiff for the first time submits claims for medical mileage. When you submit something for the first time, it cannot be outstanding and unpaid. Plaintiff inquired if the motion was still on. USAA said, yes, it is. And at that point, plaintiff essentially threatens to seek attorney's fees against USAA if they have to go through with the motion to compel. The motion, as I indicated, was properly filed because answers had not been received. And given the facts, and I've read all of the submissions, I've read all of the interrogatories, I've read it all, and those answers do not, that were submitted, do not answer the question of the PIP. So, under MCR 2.313A5, says that if a motion to compel is granted, the court shall, after an opportunity for hearing, require the party or attorney or deponent whose conduct necessitated the motion to pay the reasonable expenses incurred in obtaining the order, including attorney's fees, unless opposition to the motion was substantially justified or other circumstances make an award unjust. In this case, I do, and I have held that the motion was justified. There was no reasonable opposition to the motion to compel because by the time the motion was compelled, we hadn't answered, the plaintiff hadn't answered anything. can be awarded for the expense also approving a denial of a request to admit. I mean, so there's another theory on which costs of attorney's fees could have been awarded. Both parties have submitted the proper authority, the factors that the court is to look at in awarding what is a reasonable attorney's fees, so that at least that's something that the parties agree upon. In this case, the court is going to award attorney's fees as listed in USAA's motion and supported by the bill. I find that the hourly rate is extremely reasonable. It is below the reasonable hourly rates that are typically charged in this county or in Kent County. The plaintiff, although it doesn't feel like it, Mr. Zielinski, you're getting the benefit of basically a reduced rate that USA has a lower fee schedule with their provider, but $165 an hour, it cannot be argued that that's a reasonable attorney rate, and you don't argue that it's not a reasonable rate per hour. Then the court can adjust that number upward or downward according to the factors in the Wood case. The court recognizes that I have the discretion to do that. I'm not going to do that. In my way of looking at it, the award of attorney's fees in this case is to reimburse USAA for expenses that they should not have incurred. So I'm only ordering the amount that they were actually billed for those fees. So I'm going with the hourly rate that was charged, even though it is significantly less than what the economics study says it was. In this case, the other factors that are listed there also would, in terms of Ms. Partridge's years of experience, expertise in the area, relationship with the client, all those sort of things do justify an increased hourly rate. But again, I'm not going to do that. I'm just going to reimburse USAA for the amount that they were actually billed in this case. And the court is going to award the attorney's fees for $346.50 that relate to the objection to the order for attorney's fees. That I understand what Mr. Zielinski was trying to accomplish, but that objection was entirely frivolous. That's why at that hearing I asked him if he had a copy of the transcript, because the order said what I ordered, and to object to it on the basis that he did was not proper form, not proper function. And I guess for future reference, Mr. Zielinski, if you find yourself in that situation, hopefully not with this court again, right. If you disagree with the ruling of the court, you file a motion to reconsider.
Of course.
And at that point, they could take it up. In this case, I think if you had filed a motion to reconsider, the ruling would have been the same. I would have ruled the same way. It was still justified, but that's the way procedurally that would typically happen. So that is the ruling of the court. And Ms. Partridge, you can submit an order granting attorney's fees in the amount that I listed, and you can just put for the reasons stated on the record.
Your Honor, clarification question. You did mention the $165 hourly rate, but you didn't say how many hours total. Is it the requested amount in my conclusion, which is 25.2 hours?
I did. I ordered it at the hourly rate that you submitted, and I approved the request as submitted. I
Okay,
found that,
so,
I can put this on the record too, Mr. Zelinski. I read through the entire bill. I had spent, before entering into being the prosecutor and being the judge for about the last 3 years, I spent about 17 years in private practice, where predominantly I billed on an hourly basis. I'm well familiar with billing practices, how to account for time. I handled the civil litigation, so I'm well aware of the amount of time that things take. And as I indicated when we were off the record, that I don't take lightly assessing attorney's fees against any attorney. So I went over that detailed billing with a fine-tooth comb, and I could not find any abuse of time, any exaggeration of time that was spent there. I found it to be reasonable given the task at hand. So with that addition, I think that the court's ruling is clear.
I just have one question, Your Honor.
Yes, sir.
I was just hoping with Sister Counsel here that we would be able to, off the record, hopefully before you input the order, possibly again work out some sort of time frame on when those sanctions can be reimbursed. Because obviously with that amount, I just asked that the court allow some sort of allocated amount of time for that reimbursement.
Ms. Partridge?
Your Honor, I had submitted a proposed order to your clerk. It may be in the file. It does state, it is hereby ordered that attorney's fees in the amount of blank dollar per hour, and so you can fill it in at 165, was reasonable, and that blank number of hours were reasonably incurred by USAA's counsel for the reasons stated on the record. Perhaps you can fill that in as well at 25.2 hours, which is the amount that I had listed in my motion. And it is further ordered that blank dollar amount in costs were reasonably incurred by USAA for the reasons stated on the record. And I think that was in my description there, and it was a total of $72.44. And so therefore, the total of blank in reasonable expenses is hereby awarded to defendant USAA and then must be paid within blank days by plaintiff. And then this is not the final order resolving the last pending claim and closing the above captioned case. So, Your Honor, I am willing to give the plaintiff's attorney some time, so I can give him 30 days. That would be acceptable.
Mr. Zelinski, is 30 days enough?
I would ask for possibly closer to 90, but it's up to the court, obviously.
Well, I'll split the difference with you guys. I'll order it paid within 60.
Thank you, Your Honor.
Thank you, Your
And I
Honor.
do, Ms. Partridge, I do have your order, and we can either fill in those blanks, or if you send it to the court in a Word document, then I don't have to handwrite them in, and I don't have to have my staff retype it. So if you send it to us in a Word document, we can fill in those blanks and enter it in order accordingly.
No problem, Your Honor. So I don't need to submit it under the 7-day rule since you have it in front of you. Should I just send it to your clerk then?
Send it to my clerk, and then I'll do it, and we'll enter it according to what I just put on the record.
Terrific. Thank you, Your Honor. I appreciate that.
All right, that's all for today. Thank you.
Thank you, Your Honor.
Bye, Emily.
Bye, Robert.
Okay, I'll readmit the other 4. They're all waiting. Can I run to my office real quick
Right.
and be back?
We're back on, so I'm going to let you off, okay?
Why don't you pause the live streaming if you can, Sherry?
Yep.